Okay, so Richard's House bill on the health malpractice insurance or professional, no, your discussion.
Oh,
Yeah, your discussion. I'm just gonna read it for you, right?
oh,
Yeah, yeah.
to discuss that.
Okay, so to reestablish a government liability cap, sovereign immunity protects the government and its employees from being sued in court absent express permission from the legislature. In the NMI Supreme Court case of Maritita versus CHCC 2024, this was decided on December 2024. The court applied the equal protection clause of the NMI Constitution and found insufficient specific support. The court rejected the legislature's statutory establishment of a cap on damages to be paid by the Commonwealth for the negligent act of its employees and created a statutory vacuum. The Maritita decision undermines the separation of powers, damages the principle of sovereign immunity, and creates an emergency threat to the ongoing fiscal stability of the CNMI. This act responds to that portion of the decision concerning government liability caps. Equal protection, as interpreted in Maritita, requires that any liability cap be supported by factual findings such as actuarial studies, testimony, or statistical reports, demonstrating that the means chosen are not arbitrary. The legislature expressly acknowledges that standard and complies with it here by trying the re-established caps to concrete fiscal realities. Fiscal Public fiscal stability requires rational limits. In 1983, when the legislature first enacted a limited waiver of sovereign immunity through Public Law 15-22, and I think this needs to be corrected because 1983 should not be 15th legislature. I think it's third legislature. But the 15th legislature was 15th and 16th would be under Governor Fitio. The cinema's total budget was approximately 51 million. Today, for fiscal year 2026, the Commonwealth identified total budgetary resources of 179 million and 701 plus. After mandatory earmarks, debt service and settlement obligation totaling 41 million plus, only 127 million, almost 128 million in general revenues remains available for appropriation. Annual debt service consumes several for CHCC, Medicaid, and also CUC and the like. These fiscal realities demonstrate that the cap of $50,000 for wrongful death, 100,000 per person, and 200,000 per occurrence are rationally related to preserving stability while still providing meaningful recovery. This coverage actually reestablishes the 1983, but there was an amendment in 15 dash Public Law 15-22, which brought it up to a higher standard, which is, I think, if I'm not mistaken, it's 100,000, 200, and 300. And so this bill needs correction. As the Commonwealth budget has grown, so too have government expenses. The cinema now faces many more employees, larger operational costs, non-discretionary obligation, and substantial debt, which has required borrowing to maintain a balanced budget. Revenue has been inconsistent, disrupted by natural disaster, a pandemic, a geopolitical changes that have impacted tourism. If there were not reasonable caps on damages, large judgments could force the government to furlough or fire employees, eliminate health or retirement benefits, or borrow unsustainably to cover liabilities. Borrow unsustainably, interesting. Reasonable caps set forth in this legislature are consistent with national practice. Massachusetts, with a population of 7 million and a budget of 60 billion, applies 100,000 cap held under equal protection clause, so on and so forth. In Virginia, with a population of 9 million and a budget of 83.8 billion, applies cap of 100,000 of state's insurance coverage, which is whichever is greater. Nevada, a fellow Ninth Circuit jurisdiction with a population of 3 million and budget of 18 billion, applies a $100,000 cap upheld multiple times under equal protection, with the Nevada Supreme Court expressly rejecting heightened security. And it goes on, Guam, with a population of 173,000 and a budget of 1.3 billion, upheld its cap of 100,000 for wrongful death and 300,000 for other tort action, confirming that such limits do not violate equal protection. Any government that fails to control litigation costs risk catastrophic losses and disruption of essential services. The legislature further finds that the cost of death and claims and injury treatment have increased substantially since the ongoing cap, or since the original cap were enacted in 1983. While the number of claimants also has also increased with population and government growth, without a cap, even with valid claims could go unpaid because the government's limited revenue would be overwhelmed. The taxpayer's stewardship requires balance. The legislature has the need for meaningful recovery against the responsibility to preserve essential services, respect the separation of powers, maintain sovereign immunity, and ensure stable operations. The reestablished cap reflects that careful balance consistent with mainstream American law and with the Commonwealth fiscal constraints. Equal branches must respect their constitutional roles. The legislature emphasizes that it retains full constitutional authority to waive or withhold sovereign immunity at its discretion. This exercise of factual detail is provided out of prudence, not necessity, given the legislature's absolute authority to enact legislation. The judiciary may interpret the law, but it cannot dictate it. And so then they did the amendment. And so the amendment would go back to 50,000 for action for wrongful death from 100,000. So I'm relating back to 15-2. And liability in other tortious occurrences shall be limited to 100,000 per person or 200,000 per occurrence. And if not mistaken, the other one is also 100,000 and then 300,000 per occurrence. But we'll go back to 15-22 public law. The Commonwealth shall not be liable for any cause of action arising out of willing and wanton or reckless conduct of an employee of the Commonwealth. The Commonwealth shall not be liable for interest prior to the judgment, cost of fees, witness, so on and so forth. And so this is basically the gist of that, Richard, of the.
Do you want to read down some more of that? What
Which-
your intention about that amendment? It's very important to understand their point. The one that
The 50,000.
yeah, then it goes to the wanton and reckless. So it's wanton and reckless. The government should not be liable for that.
Also, then I'll just have to go all the way down. Liable to tort for more than 50,000 in action for wrongful death liability in other tortures occurrence shall be limited to 100,000 per person or 200,000 per occurrence. The Commonwealth shall not be liable for any cause of action arising out of willing and wanton or reckless conduct of an employee of the Commonwealth. The Commonwealth shall not be liable for interest prior to the judgment, court fees, witness fees, or punitive damages. If the Commonwealth is insured for a greater amount, the government liability shall be the same as the insurance coverage. This section does not in any way impair, limit, or modify the rights and obligation under any government insurance policy. When the population of the Commonwealth reaches more than 100,000 people according to the federal census, the amount set in this subsection shall increase by 50,000 each. An action shall not be instituted upon a claim against the Commonwealth for money damages for injury or loss of property or personal injury or death caused by the negligent act or omission of any employee of the Commonwealth while acting within the scope of his or her employment, unless the claimant shall have presented the claim, which shall name the particular employee to the Attorney General, and the claim shall have been finally denied by the Attorney General in writing. And the claimant so notified. The failure of the Attorney General to make final disposition of a claim within 90 days after it is presented shall be deemed a final denial of the claim for purpose of this section. The provision of this section shall not apply for such claims as may be properly asserted as third-party complaints, counterclaims, or cross-claims. Are you sure you want me to read this?
Just one down there, go down further down regarding
Okay.
the next one.
Actions shall not be later instituted by any sum.
No, but the jury, there's something down there about the jury.
Okay, so okay, let me just go down because it's a long, and I'll just these are with the Attorney General, but I think this is very important.
This is a proposed bill. This is what they're doing.
So this is F, section F, subsection F. Given the similarity between the federal and the CNMI Constitution equal protection clauses, judicial review, if any, of this section shall apply great weight to the findings of the legislature and a standard of review consistent with the federal law.
Okay, see. What's the other issue?
There shall be no jury trials of tort action against the Commonwealth or its employees unless the Commonwealth consents in writing before trial. So disposition of any claims by the that means you cannot have jury.
Now, pay for tomorrow, no?
Go ahead. It's up to you.
Tunay ni naholom ni House Bill 2447 ay 57 and paunlili ji office proposed bill ni para ma-deny injured person patient ni i-redown ni maulom gi CHCC for example ni mana redown pasino mapuno no istina na proposed bill lelengan na timananay no mandatory no jury trial para injured person na imuri daw. Sige na yung problema si the Speaker Edmund Gomez no members of the House ni supports din we recommend and withdraw Stephen na sa na House bill na sita go uspopota CNMI Supreme Court no decision ni ma-decide December 30, 2024 ni Sti Maritita versus CHCC. Sa na desisyon ni mas atan mas i-protection plaintiff maalok injured person adina tauto ni ma-redaw ni doktor pan health professionals ni ma-define ani CHCC ni pago no matuto ni CHCC no ma-establish as public corporation. Go be focus mas CHCC no sa bula no manahalom tautan no nigi jota no unwa ni hospital no emergency room dan una jota no delivery room dan una jota no ICU room so ini main hospital as public corporation. Ani ma-establisan no gwa maluk definition no healthcare professionals. There's healthcare professionals pago masasangan providers. So punto gini na tazaw lili gini no na okto na unggan no madisidis ti gi Maritita versus CHCC za na anti deta tutun no bumabas ti pagdiskuti pristi House Bill 24-57 debit ta comprendi afa Maritita versus CHCC didi ta ketungo afa na tutuan niya dan afa desisyon niya CNMI Supreme Court tamano sangan madisidis ti December mapedi Maritita versus CHCC sa walo kyotro panglinan versus CHCC dan Saipan Health Clinic dan si Dr. Taro Atalig just the private physician ni matsutsugi CHCC gi matsutsugi Saipan Health Clinic por rason na siya tasangan ni si testa public record no utatay testi sa charge of confidentiality gini testi malangos na desisyon gaya gi cinemalaw.org and malago sinanatan gaya desisyon gi under Supreme Court decision pues chula zo taita ne za kinipendeko na taita sti no pues yon no asene no personal opinion no si Maritita ne no iridaw jan loki si panglinan no torido si ridao sti prafta sangan afa cenunya sa no poluza no ani familia pun sinangoni fan mesangoni afa cenunya lo ridao za no ampus no mancat sega sa no ginin ni man ma no pa hospital gi CHCC man matendin ni doktor no ni CHCC yung lumapera no dalaci presyon yotro no manyago si Pangilinan manyago zano laci durante ni manyago no ga no cinoknya ipadgon po si mapera loki no ga loki redau za si tamanahono perasan lago ni pama bacogwi no afa no nisado za guaguan toda tumungo na antadingo no patafanono pa Guam o patafanono pa Hawaii pa San Lago pa mono na lugar golf guangguan pata mahano prata cek moling na specialist dan doktor dan moling na hospital pues anyway ni masusti naman mapedig sa papa na guma pues maapela ulo gi CNMI Supreme Court pues CNMI Supreme Court actually sti dos na adanya malu consolidated appeal da decide na sa istina kotti si Marutita dan si Pangilinan masusu na Government Liability Act ni mapasa ni legislatura ni gobyerno dan loki Injury Compensation Act ICA ni guazonya cap kontu na damages tamana sangan siliana pa di damages ano kontu balinya wrongful death dan kontu balinya personal injury tort ni malu kan husu no put injury on no lidawa dan kontu balinya ni pro no afana kosin iridao dan kontu balinya zonya cap tati pareo pasalinga na madiscrimina siya na patient sa gwaji i-cap no sinya maulum ni below 300,000 or 100,000 or 50,000 gwaji wrongful death pagoji over the cap ni adit ni ridongnya no za bulan no medical treatment za nasita mas no assistimento no gagwan za tima compensate persistin na okto ma kontra sa linga unconstitutional osti za isinma Supreme Court honggi si Marutita dan honggi si Pangilinan na unggan unconstitutional osti ni na no legislature ni mapasas ti ni cap i cap unconstitutional Power ji Government Liability Act ni ji procedures and todo siya gagayga dan law say i cap debe fan matulay ka sa no tikloro lilingan sinma Supreme Court na tikloro dan no tinang studio ni sti cap ni put bandan no afananya jo taza no actuary studies put sti insurance issues ni medical malpractice insurance, tayo loki data or information, dan tayo loki testimony, public testimony. Kululonya siya maniridaw. Za to afa na uchulis siya na pabidiskutis ti sa no ako patsados ti sa ni statabazo sa ipan no yalatsa no afa na nyo no sa sumonam na sagwa matindi no intero. Na apinitis ti patan pa intero sa no finata za ni matam gato la mega man hobin niya kami na dos no kasi man omko ji man omko sta man gaidat ta comprende no nelo ji man hobin so man omko lokin sinya man majuda ni doktor kemudian sin doktor datsin na fasilidad man anokko aninnya lo ji man hobin jo na apiniti sa gwaji 30 años 40 años 50 años huwennya kami pues kami kelingas tin na gua problemata dalam komunidad gi bandan hinemlo pasistingin na uchulis ti pabidiskuti sa golok no padedesis ti i bandan hinemlo the moling na no sesu manam dan animo sa kwa ni pajudo dan adisya majudo ni paifatto magi no pabiano pawai dan paifatto magi no Hawaii ni para besiga ma omti no pues es importante i decision i CHCC i Board of Trustees i CHCC CEO dan loki i committee gi doktor siya ki doktor naman matatatsong gi medical referral or healthcare network program dan loki i doktor naman matsotso di manggagi sa dalam dan di maluk quote unquote healthcare professionals di manggagi si CHCC sa healthcare professionals kinipindek ko physician assistant, registered nurse, nursing assistant, todo si allied health, radiology technician, surgeon, obstetrician, siya na doktor, todo klaseng doktor. Siya ni man ma-hire siya, man makukuni po fan matsuutsu, gizota public corporation and CHCC. So ta comprende nesti public corporation ne, gesti desisyon nesti Maritita versus CHCC. Ikot lilinga na no patisti gi CNMI government. Poseji Government Liability Act na ni cap dan ni Injury Compensation Act no inaplilikas ti gato lo ki CHCC como public corporation under the CNMI entity, government entity. Pues ipunto gini kakasangan na estina na mas parbi atuka na estina bill ni anahalom si Speaker Edmund Gomez tinahong studio sa taza no detailed study ni ji maluk no kontu man insurance no kontu na doktor giza maranas man required no medical malpractice insurance para sa private or kung man obliga loki man hire CHC doktor kung man obliga loki for manulizo niya private medical health insurance and pa fan matsuotso gi CHCC sa kinin prediction ng taza jadi naman makakover Government Liability Act lo debi listina na lai debi ni tanagwaha debi na manaholum gini na hosbio ne o mamenda si sa manaholum na debi na mandate i CHCC as a public corporation todo man manajujudan ni pofan ma amti pofan ma pera pat afan na desisyon no minalongo pareha loki para o filan medical treatment desisyon siya no debi di fan manyuli zonya no private medical malpractice insurance ja eski pawan na malago loki na pan na holum loki gini gisnalum nesti na an panamenda na holum loki i CHCC CEO na asa giza no executive director gisnalum sa giza mas no bisisidi loki po desisyon ni nemlo i tori man holum gano ni man i CHC como patients dan loki board of trustees fan manyuli zonya di maluk fiduciary duty medical malpractice no insurance fiduciary insurance loki ni skoswa decision dia lachi sinya loki man di maluk man makubri pues gua loki ekwa si Speaker Edmund Gomez dan i co-sponsors ti loki ng pendekun na gua otto lugar siya gi Amerika dan gua loki debita na gua kumutaza manaholum ni gi line mamenda line na debi na managwa loki jamaluk institutional coverage no jamaluk institutional insurance coverage para todo i CHCC as a corporation as an entity no at the same time loki ji mamande loki na todo i healthcare providers as defined in the public law ni jamaluk ni ma-establish i CHCC managwa debi na anti de firma zonya contract debi na provide gas i CHCC human resources di man hire na debi na zonya mandatory no medical private medical health insurance di po cover siya durante an man matsutsutsu gi CHCC sayangnya esti i prong cover sayangnya esti i maluk i Government Liability no Act ni pro cover i todo intermenti i governo maranas empleado lo sanga lo kisti i CHCC go be focus malpractice i CHCC mas focus sa give peligro sa bula man masosedi i gokko jan experience personally for 21 años por 20 años 30 años lili da bula hu ganun ke publiko na bula desisyon doktor siya dan desisyon ni CEO man ina dan ni komite ni medical referral man maluk man desisyon niya mo na afekta i redown niya ti man matendi umadit sa nunya gana man mate familia sa mga nyo gana man mate familia niya no sa mananangay medical fraud na po na fenano na po manano tagwini pues na maluk delayed decision by healthcare providers than healthcare officials like the CEO than board of trustees and todo no siya i doktor siya than healthcare providers so debi na manalom gini jadi na importante detailed study babas ma chondik mo na maluk mapakyawa ni phenomenon ko tisang pakyawa na clause in legislation kita ta eknuk afalilinga i CNMI Supreme Court sa CNMI Supreme Court asakang nganit na ita man unikit gini kita maranas no tayo decision niya matatay na man unikit kita maranas no unggan makumpara ta nutu na states ki continental United States no pura ofasya na cap ti state hit ani tafin man covenant man fere di man tsawit kin continental United States man tsawit man maulik siya na hospital especially todo from cancer treatment to heart disease to todo na neurological disease but afasya no man tsawit lugar no sa tsawit gano zong gagit no kana 7,000 4,000 miles 3,000 some miles ginin Hawaii and 7,000 na 5,000 miles ginin California pues idota access medical access quality medical access facility no makarit ni tototano sa tsago no gasto dan tempo ni pondingo itano lo gaigi i tratamento ni moling ni lalamo no homlo lo ita na gwini i CHCC na decision ni House Bill 24-58 I'm sorry 57 no te protette i patient injury no taite i proposito te protette pubblico te protette i patient injury jani wrongful death ni malug negligent i gobyerno or negligent or reckless afane decision i empleado gi hospital pat afasya na doktor pat healthcare professionals no mas aatan i gasto ja debin ta comprende na na bill guasti no dongklo na malak philosophical question no mga maso ipumalo siya na states asu hita gani sa Maronas debin ta faisin na debin na detailed studies about actuary studies data information and to the public testimony that debin ta diskuti loke gano uno afa na hafta mano para ta no i pressure nesti maluk iridam tauto no itaw ta hafta mano pon calculate po quantify ini sita studios tisingan na pon sulia po di gaigi no Wisconsin or po gaigi no Guam pat gaigi no California pat mano na lugar no tisingan ta sulia donya no statutory no apa na maluk no donya rational basis donya decision ni mafatina sisti i statutory ni proma cap an sita ta tsoge mas tamana je masasangan ni galmi sti Martita versus CAC na decision nan tamana sangan loki gini gi House Bill 57 si House Speaker Edmund Gomez na unggan bula dibi dan bulan no apa na maluk no timigay gini matutuni si Government Liability Act 1983 or 82 todo sa pago Edzigi man concern ko pata konni magi man kwalidad siyang da doktor sa Maranas. Sina ta konni magi man kwalidad na doktor. Law anisita ta disidin molik. Sa debita balansa loki i todo siya insurance companies loki mahando si medical malpractice insurance ta balansa dan ni loki i interest i patient ni man iridaw dan ni loki man matay. No, sa aksidenti sa laci decisionnya doktor, pat laci decisionnya medical referral, pat laci decisionnya sa trasal, todo no siya. Bula trasal ni CHCC. Pues importante na debitan balansa no todo. Tisina ta na chonikas te mona ta pro ta pakawa mona sina na legislation. Pues ito talo i pron apa se maluk pron kapa estina jelinga pon kapa pon birtatti gizi 1983 na cap para the Government Liability Act lachi so sa gitu tun kamu ma fenno 1983 up to 2025 taja studio ai gina tempo didida doktor ne no ja manisita mas man doktor na doktor lo manonggizo na i doktor kun na pasi molding na sweldo ne jan kwalidad na doktor jan dinanci ma hire ni CHCC ne no management dan experience na doktor dan kwalidad na medical equipment manggagi sinalom sempre ta pasi molding ne debin fan ma pasi molding ja sinya loki ma mandate gini na line na ma pasi loki zonya insurance ja ma prete loki mandate na zonya private insurance pa to the healthcare professionals no ja ma prete loki patient injured patient potential injured patient sa man tautuit man lalachit lo kumuta ribaha ini lachi ne di doktor ne no pues sempre mas dididik no manirida tauto mas banonokkan ini to tanu jan audition er children maranas lo stina oktu pagune ababa salan ni para kesa ni patient no para fa mapasa no 50,000 wrongful death 100,000 no any other tort than up to 200,000 per occurrence then is loki private no cap ni that $300,000 no American insurance so debi na maatan sti da debi na mas manai no maluk no chance injured patient ne no but ini lachi ni doktor ja lachi ja no iridapan mate patient debi manai mas no kampu ni para maluk pa pastati minasapit niya no bulan minasapit na piniti todo klase ne no if na americano pain and suffering humiliation todo klase ne the cost todo panon pa wai panon pa sanlago todo guagwan pois que é importante na empatata no za usa fashion talong bay favor na speaker Edmund Gomes withdraw sti zon na suasti na za zon no ma studia uma decidin maulik esti na falanya esti na desisyon da ma studia sa nigi CHC I mean Marvitita versus CHC under CNMI Supreme Court ma decidin na importante na managwa no studio sa tisinya na para blanco alam pumapasa legislature da todo studio da pongkapa sa nilala tautos ti itano ne pues yo lokki no importante lokki na debi lokki na estina oktu ne sa sangan na pumarespeta separation of power debi na marespeta esta CNMI Supreme Court asasangan na debi na magwa studio lo ani machoges ti na tinchegwi estina oktu in choge ne House Bill 24-57 tini SG na afalel niya in chegwi prembira tal tatig 1983 pues anesita kwa studio ne natatan kontu be taza tatungo kontu be man lalachi doktor ki hospital dan kontu man mamate gini lachi ni doktor dan kontu man nirida gini lachi doktor taza studio ne no da jigina no man govna amasi injured patients ne dan todo manirida dan izi gana man mate gini ni decision ni doktor dan durante ni operation pat afane pues taza makpa gan no pues gana toto tisinya no man hire no lawyer ni pro abogado ni po ni representa ni pro atitudes ti pues no fashion na debi na atan maulik sti za no debi galo ki respeto ni legislature kolonya sti House Bill ni amzo ni Speaker Edmund Gomes na go introduce sti debi lokin no respeta CNMI Supreme Court afal lelengnya no sa jigin na separation of power then they bilokin na co-sponsors si Representative Adan, si Representative Marisa Flores and si Representative Yumo o marespeta lo ki CNMI Supreme Court sa CNMI Supreme Court nunggan matitepili ilay lo ilay ne ito kami kilingan na afa mapasa gi legislatura za matu za mapablo za matulog CNMI Supreme Court ito kami kilingan na formatatija skala lachi sa siya matitepili ilay Dati sinya na pon mandate gwagen na taluno gini yaktu ne nalilingan na pon mandate na debi na umatatizi i federal guideline federal interpretation ni porma an skoso porma atan sti na House Bill 2457 kung mapapasa kung mulai. Pos kasi importante na debe na gua no mas studio dan mas inadahi ni tamanin ni pramaputei sa patient dan tamanin ni porfan ma tsogi todo istine i cap sa gof komplikao sti cap sa tesinya tamano sa sangan gi fenana debe ta faisin molikit half after mano para takat kula izonya damages ne iridawnya injured patient dan familianya or iji maluk matay patient iji maluk wrongful death gini ni CHCC no gagigal mizonya public corporation facilidad jani doktornya jani zonya no employees like the healthcare professional employees as defined in that public law na create i CHCC. So isti siya na klase na kasi grabe tagafatan sa mga matsonik stimona sa tamano sa sangan na isti na House Bill 24-57. Isti na House Bill tiyas popotay i publiko, tiyas popotay i interest i patient, dyan man malongo, dyan man namasi, you know, da man kilizonwit, you know, no bula man manonggi zo sa Kristo dan todo siya si Santa Maria dan todo siya manyantos na Katoliko zo. Da go ko bekan zo kuno uno na Katoliko. Da no isaw sti na totso i parampakaw tagwini sa no importante na tajuda i manodinario ni mamobli importante na tajuda lo ki todo siya siya na tauto kuno maniridaw ni man matugat ki hospital, you know, dapat man matuka. So i desisyon ni management is CHCC asti dan ni board of trustees dan ni desisyon ni legislatura asti dan ni magalay dan ni executive branch gusto magalay siya asti po reglan maulik tamano sti da mabalansa loki sa tiu diskut tu malelefazo na nggan tumuno pa ekonomiya tumuno papa i revenue no general revenue zabula no maluk mandatory earmark no appropriation dan loki wa debt service dan todo no siya no na obligasyon retirement dan apa siya lo nila la toto sita sasangan nila lata todo dapat tapan malongo no lo importante na ta protehi ta konni manolom an man hire ne an man hire i tauto i CHCC management man hire no healthcare providers, healthcare physician, ni pro attending gi emergency room kulolonya, dan pro halum gatu gi